The judges of the court. Hear ye, hear ye, hear ye. All persons having any business before this Court of Appeals, held in and for the state of New York, may now draw near, give their attendance, and they will be heard.
New York statute of limitations will be applied, but 202 is part of the New York statute of limitations, and that does require a minimal choice of law determination. I believe that's what this court recognized in the Smith-Barney decision. Finally, I'd just like to address the ambiguity point that plaintiffs have raised. We would submit that since this court's decision in Martin versus Julius Stursick, what accrual of a cause of action means for 202 purposes is clear. What the plaintiffs are asking is for this court to add another layer of confusion to 202 by having multiple definitions of accrual of cause of action. Thank you.
Thank you, Mr. Clerk. Smith-Barney, Shearson Incorporated, and Greenhill against Sakharov. Smith-Barney Incorporated against House. Mr. Fenster, good afternoon.
Your Honor, yes. May I reserve 10 minutes for rebuttal?
10 minutes.
Since we've already had a case on eligibility and one on ambiguity, and since Mr. Lipner and I argued Smith-Barney versus Lucky 2 years ago before this court, possibly I can get through the case.
You must feel very much at home.
Very quickly. It's very gratifying. There are two issues before the court today. One is, does an eligibility requirement contained in Section 15 of the NASD Code present arbitrability issues? And number two, if so, are those issues for the courts rather than arbitrators to decide? Our first argument, and one that has been adopted by the majority of circuits, is that the plain language of the Section 15 and other eligibility requirements, which are contained in every SRO's arbitration rules, plainly is jurisdictional. And that is based on both AT&T Technologies, the Supreme Court's definition of arbitrability, which is that if the provision creates a duty to arbitrate, and the question of what issues must be arbitrated, you have a question of arbitrability. Together with first options, which is the latest Supreme Court authority on the issue of arbitrability, we know that only those disputes that the parties have specifically agreed to arbitrate may be arbitrated. Yesterday, during the Kidder-Peabody...
You would win as long as it's not unequivocally clear that arbitrability was to be determined by the arbitrator.
Exactly. Under first options, there has to be a clear...
As long as it's ambiguous, you would claim you would win.
Right. In the face of silence or ambiguity, first option says arbitrability is for the courts. And there has to be a clear and unmistakable expression of the party's interest to send the arbitrability issue to the arbitrators. And we don't believe the any controversy language, which was involved in Lucky, or Section 35 that says the arbitrators can determine the applicability of these provisions, that either of those is a clear and unmistakable expression of the party's interest.
Would you say that your position is sustained by the very fact that an awful lot of federal judges have found it unclear as to which control?
Well, I like to think that the majority of judges who have found that the federal courts have found that it is clear, have better reasoning. because of this. There's a lot of confusion, and not since Smith-Barney versus Luckey, but prior to that, there's a lot of confusion about what is arbitrable and non-arbitrable, what substance and procedure, what you label an eligibility requirement. And I know the question yesterday during the Kidder-Peabody case, which was somewhat premature, about whether this was really just an issue of timeliness. I mean, there's a new label, that it's simply timeliness. And what I think the only basis for clarity in this area is, lest you see Mr. Lipner and I here 2 years from now arguing what's procedural and what's timeliness, is this. The language eligible for submission to arbitration, it only appears in 5 places in the code, and every place it is jurisdictional. NASD Section 1, which is now Rule 10101, is entitled Matters Eligible for Submission. And that says any matters related to the business of a member is eligible for submission. 10301 takes those matters and said that will be applied even if the customer doesn't have an agreement, if the customer just arbitrates. 10301A says class actions shall not be eligible for submission. And 10334 says large and complex actions shall not be eligible for submission unless certain criteria are met. Together with Section 15, which says claims based on transactions over 6 years old are not eligible for submission, these are jurisdictional. The timeliness provisions of the NASD Code say, in 10314, you have 20 days to submit your answer after the statement of claim is filed. Or 10321, you have 20 days, party must within 20 days, made within 20 days, submit a document request on the other side. Those don't have the magic words eligible for submission. And I don't say magic words lightly, because one of the first cases, the Third Circuit in Hartman, said, look, eligible means worthy of consideration. Submission means submitting to the power of authority. The plain language, we think there's only one reasonable way to read this, and that means it's not worthy of submission to the arbitrators. It doesn't even enter the arbitral process. It doesn't get through the front door, let alone any windows, to get to the arbitrators to decide. So because of that, it's jurisdictional. And let me just take 2 seconds. I understand from yesterday that we're not supposed to ask the question, so I'll put it this rhetorically. If you and I decide that we're going to enter into an arbitration agreement, and we decide we are not going to try to arbitrate, we're not going to allow the arbitration of any claims based on events prior to today, no matter what the subject matter. We say anything prior to today is not eligible for submission. I believe that 2 years from now, if you came to me and said, I have a claim based on something in 1995, I would be able to go to a court and say, we did not submit this matter to arbitration, because the language of our provision indicates that the parties didn't submit the language. It didn't submit this subject matter, which happens to have a temporal element, but didn't submit it to arbitration. And that's very different, as Hartman found, from a statute of limitations. It's very different than if we said, look, we're going to have claims in arbitration, but we're going to say attach a 6-year fraud statute of limitations from the event, or 2 years from the date of discovery. Because in that situation, we're not identifying the universe of things. We're saying there's a temporal element relating to subject matter that carves it out. We're not allowing it to be submitted to the arbitrators. And Smith-Barney versus Luckey is interesting, though it's potentially confusing in this regard, because Smith-Barney versus Luckey did have a temporal limitation. And there we said that the party's reference to a New York choice of law clause incorporated New York's statute of limitations to govern the arbitration agreement. It didn't matter that the arbitration agreement said any controversy, or that the NASD code said Section 35. The party's reference to New York law was sufficient to incorporate the statute of incorporate CPLR 7502, which allows courts, not arbitrators, to decide. So we had a court. We have a decision on the books which allocates the powers of courts versus arbitrators by virtue of a reference to the New York choice of law clause. And the reason we did that there, or the reason I believe you did that there, was that It's not just any controversy that we're arbitrating. We're arbitrating any controversy in accordance with New York law in Lucky. Here, we're arbitrating any controversy in accordance with the NASD code, and the NASD code has its own jurisdictional limitation. I don't think anybody is going to argue that class actions, if someone filed a class action in court, we couldn't go in arbitration, we could not go to court to challenge it, or a matter that was not related to the business of a member. So, by the way, you also have a jurisdictional limitations here that have temporal, here in this court, I mean, CPLR 5513, which allows 30 days to bring an appeal, while there are other provisions that might extend it. The thing about the jurisdictional limitation, even though it has a temporal element, is that it can't be waived, it can't be tolled, it can't be extended. And that's true. For that reason, it's different also from time limitations.
Thank you, Mr. Fenster. Mr. Lipner?
Thank you, Your Honors. I find it somewhat surprising when the petitioner comes and suggests that a term that's not expressed in the agreement and that's contained in something called the NASD's Code of Arbitration Procedure is a substantive limitation on arbitrability. Mr. Fenster gave the example that if you and I agree that we're not going to have arbitration for things that are more than that's happened before today, if we agreed to that, then we'd be bound by it, and that would be a question for judicial interpretation. But that's not what the parties agreed to here. Here, the agreement, at least in the House case, provides that any controversy arising out of or relating to the accounts or the investments, or with respect to this agreement, shall be resolved by arbitration at the NASD and pursuant to the arbitration procedures then in effect. There's nothing in the express terms of this agreement that support Mr. Fenster's position.
Eligibility?
Well, but there's nothing in this agreement about eligibility, and there's no express time limitation.
But
We have to look somewhere else to
It
find it.
doesn't look like, does it? Doesn't look like a typical procedural statute of limitations, which certainly does not generally speak about eligibility for submission. You can't go to court. Generally speaking, statute of limitations are defense matters. So isn't that enough to at least create a lack of clarity which has to be resolved under the case law against you, doesn't it?
No, I don't agree with that at all for two reasons. First of all, I'll take the second reason first.
Right.
If there's a lack of clarity about whether this goes to arbitrability, I submit that the doctrine of contra pro forentum, it's their agreement, works in our favor, and there's nothing in first options or the presumption that Mr. Fenster relies on that's supportive of his position, because the first question is, does it go to arbitrability? If it's ambiguous on that question, this court should presume it doesn't go to arbitrability. If the court finds it does go to arbitrability, then Mr. Fenster and Smith Barney get the benefit of the first options presumption, but there's nothing in first options that compels this court to say this goes to arbitrability. That's the first point. So tiebreakers on ambiguity.
A condition preceding to some eligibility to arbitrate doesn't go to arbitrability?
Oh, but wait a minute. Now, this court has said in both United Nations and County of Rockland against Premiano, and that's my second point, that we make a distinction between conditions to arbitration and conditions in arbitration. And in Premiano, the court said that a condition to arbitration is one which is unrelated, and I'm quoting, in a precise sense to the arbitration. And it gave us examples having to submit the matter to the architect to get a certificate, or having to submit a matter to the partners for resolution before you enter into this dispute resolution process. Then it talked about conditions in arbitration, and it gave as the example a time limitation on submission, and that's this case. Here is a rule in the arbitration agreement that refers to a time limitation on submission, and that's precisely the example that this court gave in County of Rockland. And then the court in County of Rockland went further. It said, you know, arbitration's a matter of contract, And if the parties don't like the lay of the land with respect to conditions to arbitration and conditions in arbitration, they could make a better agreement. And as the Second Circuit pointed out in the Bibic case involving this identical issue, this is not the agreement you would make if you wanted to make clear that this was a time limitation on arbitration as opposed to in arbitration. And if you look at the history of the NASD's eligibility rule, as is set forth very nicely by Professor Katsouris of Fordham Law School in his articles, this was designed as a rule of administrative convenience for the NASD, for them to decline their arbitration facilities in situations where they thought the courts were better equipped to handle them because of the presence of discovery rules, of disclosure rules and things of that sort. Again, that's not this case. This is not the NASD coming along and saying, we're going to decline our facilities. This is the brokerage industry engaged in what I term in my brief a Stalingrad defense, in which everybody who brought an arbitration 6 years after the purchase, no matter what the concealment, no matter what the brokers did and the brokerage firm did to hide from the investors what was going on, 6 years too late, you lose, no excuses. And it's very interesting that Smith Barney, that made the argument about timeliness in the Lucky case, and that brought that case before this court on statute of limitations grounds, does not assert here that the statute of limitations has run, that it should have a judicial resolution of that issue. No, what they want this court to do is to remake this agreement, to take this agreement that doesn't say anything about the eligibility rule, that refers to arbitration procedures, and say that, well, there's this substantive limitation in those procedures, as corny as that sounds, there's this substantive limitation in those procedures that this court must interpret. The fact of the matter is, this is precisely the kind of issue that belongs before the arbitrators. They're the experts. They've seen these limited partnership cases. This court hasn't seen any of them and will never see any of them. They're the ones who've looked at the injustice of the eligibility rule. And I remind this court what Justice Omansky said in the one case that did land in court, that the eligibility rule is unfair with regard to limited partnerships because it cuts off these claims regardless of what happened and punishes the innocent investor who was not a drafter of this agreement and who is now victimized by it. The Federal Arbitration Act says, and it's very simple, and it's been very limited by the courts, it says that people who make arbitration agreements should stick with them. They should be bound by them. They should not be allowed, and I use the pejorative, to weasel out of them because on one particular day or on one particular case, it suits their purpose to be in court. That's what's going on here. We have an industry that insists its customers go to arbitration. And I know Mr. Fenske is going to say that you, because he said in his brief, you could have a cash account and not agree to arbitration. Your Honor, my client had a cash account. She didn't have options. She didn't have margins. She didn't have futures. She had a cash account. And she's 86 years old. And now she's got $235,000 worth of zero in a limited partnership. Her muni bonds were sold. Yeah, and it was more than 6 years before the thing was filed. But her muni bonds were sold. And now not only does she have zero, she has something called phantom income. So every year on her income taxes, not only doesn't she have an asset, she's got a liability. That's what this broker did to this client who's 86 years old. And now they take their agreement and they want this court to read into it something that is just not there. There is a lot of evidence. I want to turn to the second issue. Because if you find that this goes to arbitrability, and I don't think it does, and I think that any ambiguity has to be resolved in favor of Mrs. House and not in favor of the firm that drafted it, but if you find it goes to arbitrability, then you get into this first options presumption and the question of whether there's clear and unmistakable evidence that the parties committed this issue to arbitration. And I submit to you there is. First of all, the parties agreed to resolve all disputes in arbitration, all disputes concerning securities. This isn't a case about a fender bender in the parking lot between the broker and the customer and a question whether that's within the scope of this arbitration agreement. You look at this arbitration agreement. This case arises out of and relates to the accounts and the transactions and the securities. The second thing is this dispute about eligibility relates to this agreement. And disputes about this agreement, any controversy about this agreement or the breach thereof, shall be resolved by arbitration. The third point is the express terms of the agreement say nothing about eligibility. And I think that when you have an agreement that doesn't say anything about time proceedings or time limitations, you shouldn't be able to then come along and say, well, in the rules of the Arbitration Association, there's a time provision, so we'll read that into the agreement as though it were there. It is not there. They could have put it there. They didn't do it, and this court shouldn't make the agreement.
Well, if Section 15 does apply, what statute of limitations does apply? Is there a statute of limitations?
Sure, there's a statute of limitations that applies, and I think under the Manhard case, it's the statute of limitations in the law of Florida. This lady lived in Florida. She still does. And under the borrowing statute, barring some decision in this court that the New York choice says, and by the way, Judge Wesley, I would have agreed with you, that the New York choice, and that's precisely the argument I made in Manhard, that the New York choice says apply New York statute of limitations. But I think under the prevailing law, we get Florida's statute of limitations, and the arbitrators will decide that. And the arbitrators will also decide whether the 6-year eligibility period has run. The point is, it's not for this court to decide. That there's been a commitment to the arbitrators that they should decide this. And I don't go quite so far as Mr. Fenster to say that in every case of ambiguity with regard to the who decides question, it must always go in his favor, because at some point you run into contra pro forentum, and at some point you run into the principle that you had a chance to avoid this. If you had drafted an explicit, articulate agreement, he and I wouldn't have been fighting about this for the last 5 years. Thank you.
Thank you.
This is the last round.
Mr. Wilson? No.
Good afternoon, Your Honors. I recognize that I stepped into some battle between well-seasoned veterans here, and I apologize if I lack any insider information on the history of their dispute.
Have you filed with the SEC? It's a long-running battle.
Your Honors, it bears emphasis that Dr. Norman Sacro thought his monies were invested in conservative, secure investments. Unfortunately, he was wrong. Smith Barney and Company decided to put those monies in highly speculative limited partnerships. They dwindled his funds from $187,000 in June of 1984 to a mere $15,000 upon his death in 1992. Rather than defend the underlying merits of this claim, and rather than comply with an arbitration agreement that it drafted and in essence foisted upon my client, they decided to institute arbitration-related litigation. We asked this court to affirm the decision below, to prohibit them being Smith Barney, from engaging in this type of litigation and order the parties to arbitration. We do so essentially based on 3 different theories. The first is we asked this court to define narrowly issues of arbitrability, as the First Circuit did in Eli. In instances where you have an agreement, which we do here, there's no dispute whatsoever with respect to that, and the underlying dispute falls within the ambit of that agreement, which there's no dispute here. I mean, Smith Barney essentially raises NSD Section 15 to say that it falls outside the scope of the agreement, but the underlying dispute itself clearly does not fall outside of the agreement. When you have those 2 instances, or those 2 variables, we ask this court to presume that the parties intended to arbitrate all other claims. This presumption, it makes sense. It makes sense to presume that where parties have an agreement and the underlying dispute falls within the scope of that agreement, they intended to arbitrate all other related matters to that arbitration agreement. It also comports this presumption with the strong federal New York State policy favoring arbitration. And it gives effect to the intended benefits of arbitration.
How does that fit in with first options and AT&T?
I think it fits in.
Would seem to say that the presumption goes the other way unless it's unequivocal that the particular dispute is arbitrable, doesn't it? Or am I misreading it?
Judge, I wouldn't suggest that you misread any case. But
Wouldn't be the first time.
as Eli made clear, first options in AT&T talk about a presumption of who decides issues of arbitrability. What I'm asking this court to do is, before you get to definition of an issue of arbitrability, or you define a Section 15 dispute as an issue of arbitrability, I'm asking this court to apply a different presumption, a presumption that comes before that, and basically say that where you have an agreement and the underlying dispute falls within that agreement, we presume that it's not an issue of arbitrability. So this presumption that I'm asking this court to adopt does not run afoul of first options or AT&T, and the Eli court made that abundantly clear. The second theory is slightly different, and it was one that also was recognized in the Eli, but also by a number of other courts. The Fifth Circuit, the Ninth Circuit, just to name two other circuits. And that is, even if this court determines that Section 15 disputes fall within arbitrability, we ask it that it characterize it in terms of procedural arbitrability. In essence, an issue in arbitration, a timeliness issue. This characterization would be in accord with County of Rockland, which was mentioned quite eloquently by Mr. Lipner, and also reaffirmed recently in Lucky, where the court stated contractual time limitations agreed upon by the parties are for arbitrators. We ask this court as an alternative to define or to characterize Section 15 disputes as just that, time limitations for arbitrators to decide. The third and last theory, if you will, is even if we assume, or even if this court decides that Section 15 disputes do in fact raise issues of arbitrability, first options make clear that all Smith-Barney at that point is entitled to is a presumption. It's not an irrebuttable presumption. That presumption could be overcome by clear and unmistakable evidence. There's one thing I want to talk about before I turn to what the clear and unmistakable evidence is here. Smith-Barney keeps repeating that Section 15, or the language of Section 15, is a substantive jurisdictional requirement for courts to decide. They provide us with a tutorial on how to use Webster's and how to deconstruct sentences for what shall be eligible actually means. Nowhere in Section 15 does it say courts shall decide what claims are eligible. It doesn't say that. In any event, in accord with first options, and if this court was to decide that Section 15 raises issues of arbitrability, we ask this court to turn to two, I shouldn't say provisions, first to the language of the contract itself. Any controversy relating to this agreement shall be arbitrated. Plain and simple, clear and unmistakable. The First Circuit so found, in fact, characterizes that language as inclusive, categorical, unconditional, and unlimited. The second, if that doesn't satisfy the court to show that there's clear and unmistakable language, is Section 35. Section 35 makes clear arbitrators, and I think Mr. Fenster mentioned Section 35 once, and it's probably for good reason. Section 35 makes clear that arbitrators decide or interpret and apply the code provisions, including Section 15. He will probably counter, as he did in his brief, that Section 35 is a catch-all provision. If he wants to put it in those terms, fine. It catches and answers the question of who decides eligibility requirements. The arbitrators do. That is all I have to say. I will not indulge the court any further. If there's any questions, I would be more than happy to answer them.
Thank you, Mr. Wilson. Mr. Fenster?
Thanks.
may be obvious why I asked for 10 minutes for rebuttal at this point. The arguments against the application of Section 15 as a jurisdictional eligibility requirement are, number one, taking Section 35, which I mentioned before. Section 35, which says that the arbitrators can determine the applicability of all of these provisions in this code, is also subject to NASD Section 1. Section 1, which I quoted before, says the only thing that these arbitrators get before them are, the only thing that's eligible are matters relating to the business of dispute, and only eligible matters may be arbitrated under this code. So by the time you get 34 sections down, when you have a section that says we can determine the applicability of the code, I'd say it's not clear and unmistakable that they can determine ineligible matters or determine the question about what's eligible or ineligible. I would say that means they can only determine the applicability of these provisions to eligible.
How would you determine whether a disputed issue as to whether it's related to the business with the customer? Would an arbitrator do that, or would the
Court.
Court would have to do that.
Listen, beg your indulgence for some other hypothetical. This is the way I've been thinking about it. If Mrs. House came into the broker and she complained about her account. She was there solely for the business of her business. And on the way out, she slips and falls in the lobby of Smith Barney. She sues in court, and Smith Barney comes in and says, motion to compel arbitration, and court, you can't decide this because you can't decide whether this is a subject matter dispute under the rules, because Section 35 says any and all controversy. First of all, my agreement says any and all controversies between us, and second, Section 35 says it's arbitrators who determine. Or if Mr. Satchero came into the broker and shot the broker, and the broker sues him, and Mr. Satchero comes into to court and says, this is arbitrable. And court, you can't even determine whether it's arbitrable or not, because the arbitrators have the power to determine whether this is eligible for submission.
You've been thinking a lot about these hypotheticals because you've had all these years between Lucky and now and the other potentialities, but they seem very far off the reservation from what is involved in these two matters. And it also seems very far from arbitration, preference for arbitration, respecting arbitration agreements that your industry and your client presents to its customers. It seems like a tough fight up the hill to keep this away from the arbitrators that you want so many of these matters to go to. And how do you justify that?
It's simply, we didn't agree that all matters should be arbitrated. We certainly didn't agree that matters over 6 years after the occurrence or event should be arbitrated, not from the beginning of time, because from the beginning of time, Section 15 has been in there. And despite Professor Koutsouras and despite other people saying that this was entirely unfair or saying that there were adhesion contracts involved, NASD Section 15 has not been changed. The NASD Code has not changed in 20 years in this respect. Nobody has said, well, it really should be 12 years, or it should be 6 years from discovery. In effect, what they did was they established a 6-year statute of repose, but it was even more important than a statute of repose because it was originally parallel with the amount of time that securities firms had to keep papers, had to keep documents. You had a 6-year requirement. And they recognized the unfairness of having someone come in and say, my broker lied to me, when the unfairness to the securities firms, when the securities firms had no documents one way or the other because they'd already gotten rid of it. 6 years was also considered longer than most statutes of limitations. With the exception of New York's 6-year and 2-year rule, most statutes of limitations around this country are shorter than 6 years. So the way I justify that is by saying we never agreed to arbitrate claims over 6 years old, just like we never agreed to arbitrate claims that were not within the business of the member. And yes, the two hypotheticals I gave you were far-fetched, but they're meant to point up where you don't have a timeliness problem. That what is the business of a member? Because arguably in both of those you have a business of a member. It's a matter for the court. It's not the arbitrator. The court can't be told you can't decide whether this is within the scope of our agreement or not. I
think opponents to arbitration have been saying that since the beginning of this century, and if Cardozo could speak up there and come down, he'd say, we're still doing this and we're getting into the next millennium?
Well, I feel the same way. I feel the same way. I think that if you read the eligibility requirement to be ambiguous in the face of first options, We're going to be back. This will go on and on. The strategy on the opposing counsel here is you take first option's assumption, which says arbitrability issues. We'll start with AT&T. Arbitrability means, does it create a duty to arbitrate? Are these particular issues under the agreement or claims? And then first option says those questions are for the court. Well, now we have a new assumption created by Elahi that precedes the first option assumption or turns it on its head, depending on your view. It says before you get to whether the definition of arbitrability, you have to imply other presumptions. And there's nothing in first options, and there's no case that supports Elahi's creation of some new FAA presumption. Now, we have a New York choice of law clause in this court, too, in this case, too. But our position is fairly clear. Under New York law or under the FAA, the result here is the same. It's both arbitrability and the presumption is both for the courts. Quickly, on the draft, the ambiguities against the drafter, this is not something that we drafted. This is something we've adopted, but the NASD drafted the rule, sent it to the SEC, and we are required to have, in accordance with the NASD rules, in any written arbitration agreement we have. Second, as far as the intent, you know, I have great respect for Professor Katsouris, but he was one of approximately 15 people who drafted this, and he is not telling us after 20 years what eligible for submission to arbitration means in the other the other provisions of the NASD code which use eligible for submission to arbitration. It's not even shall not submit, it's you shall not be eligible for submission. It's even more attenuated. The Department of Transportation, don't even think about parking here. I mean, you can't get into the front door of arbitration. I'm also told, though, I'm told by my client, and this was a pure sympathy point, that Mrs. House made money on her limited partnerships. I don't know the details of it, but just prior to this, I don't think that these accounts went down to
Is that in the
zero.
record?
No, because the merits of the dispute, there's a lot that's in the briefs that are not should not be before the court because they're not in the merits. I mean, and I think both sides have done it. We tried to do it with documents that are on Lexis and that you could look at, but I would say what we're trying to do here is not have brokers sitting in smoky rooms trying to figure out how to victimize 86-year-old ladies. What I would say is that people who would act sooner, not wait 6 years, might be a little younger by the time they get their claims.
Thank you, Mr. Fenster.
Only be 80.
Matter of Board of Education, Monticello School District against Commissioner of Education and Herzog.
They're all friends. I said they're all friends.